In this video, we're going to talk about state of mind. As we mentioned, for criminal liability to attach, there have to be three things. There has to be the criminal act, there has to be the criminal mind or the criminal intent, and then there has to be concurrence of the two. The fancy Latin word for criminal mind is mens rea. It literally means guilty mind. When you break the law, it's not enough that you just violate the law. You do something that is not allowed. It has to be voluntary. It has to be something that you chose. So there's a mental state, a mental element that goes with it. Back in the common law, they realized it's not as simple as we might think. So say you push somebody down and then they crack their head and they die. You meant to push them. You didn't necessarily mean to kill them. So how do you handle that? What's the mental state there? Back in the horse and buggy days of the common law, they made up a distinction. They talked about specific intent and general intent. If you meant to do what you did, then you had general intent. General intent is meaning to do what you did. It isn't meaning the specific outcome. So you push a guy down, you meant for that to happen. But then he cracks his head on a rock. That's not what you meant. They would refer to that as general intent. Now, if you did mean for him to die, they would call that specific intent. So they had specific and general. Murder is a specific intent crime. You specifically intend to take someone's life. But what if you got into a fight, like a bar fight, and somebody hit their head on the table counter or the chair or they hit the floor or something and they died as a result? That was not the intent of your little bar fight. Under the common law, they would call that general intent. You intended to fight, but you didn't intend. And today we would call that manslaughter. And we make a distinction. There's still a dead guy, but in one case, you intended to kill, and the other one, you did something that resulted in that person's death. So we make that distinction. We still make that distinction today. And they were trying to make that distinction way back in the days of the common law. It's kind of tough. It's kind of tough because there are a lot of things that might get mixed up when we talk about intention. What I want to talk about next are some instances that do not count as mens rea or intent to do an act. There are some things that sound like it but aren't it. And one of them is something called scienter. Scienter is a fancy legal term for knowledge. Sometimes there's a specific fact you need to be aware of in order for us to charge you with that particular crime. For example, battery on a law enforcement officer. What do you need to know? Oh yeah, that's a law enforcement officer. If you thought that you hit just an ordinary person on the street, you could not make out the case of battery on a law enforcement officer. You have to know that they're a police officer. Receiving stolen property. You have to know it's stolen property, or at least have had a reason to suspect it was stolen property. And if you didn't, then just the fact that you are holding on to stolen property is not in itself a crime of receiving stolen property. A lot of people could be sold something and innocently purchase something. If someone sells you a TV for $1, you have good reason to wonder where they got the TV and how come they're selling it for so cheap.